Hey, old folks! This is a case we haven't heard about in quite some time. It's the Murdaugh case. Remember? The scammer, fraudster, whatever's genuinely really bad guy who was charged, tried, and convicted of killing his wife and son. And at the time, I asked the question, why do they have to bring in all this other junk if their case is strong? Why? And now we had the thing with the Clerk of Courts, and she's getting charged with misconduct, not jury tampering, but that actually speaks to something else in this. Now, what has happened? Well, let's go to Fitz News. Thank you for reporting on this. See here. It might have made a difference. Alex Murdaugh's attorney reacts to hidden texts. Alex Murdaugh's defense attorney says newly surfaced text messages between the disbarred South Carolina attorney and his alleged drug dealer, Eddie Smith, could have altered the defense strategy in the Murdaugh double murder trial, if only they had known about them. Now, you might ask yourself, well, he's his defense attorney. Why didn't he tell about it? He doesn't have to. And remember, folks, it all has to go through the prosecution, and then the prosecution hands over to the defense in discovery. Remember this, please, that a defendant do not have, never have, will not ever, well, the rules might change, but they don't have to prove anything. It's 100% on the prosecution. Hence, everything must be handed over to the defense. And here it seems, they didn't hand over quite important stuff to the defense. Dick Kapotian told Fox News this week, "We were not aware of these texts. It may have made a difference in our decision not to call Eddie Smith to the stand." Harpootlian's comments come on the heels of Fitz News' exclusive report last week highlighting dozens of previously undisclosed messages between Murdaugh and Smith. Let's see here. And here it is. Hey, brother, I need to get the check you forgot Friday so I can give these boys some more. Okay, I will be back this afternoon. I've had time collecting. We'll get that done too. Okay, brother, just give me a holler. Give me the hashtag again. I cannot get through. Don't know what's going on. Blah, 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 blah. And on and on and on. So it seems like a lot of texts between Eddie Smith and Alec never found its way to the defense. Now that is a Brady violation, supported by Giglio. These are the two main cases when it comes to turning over evidence to the defense. These text messages, although we only saw a few of them here, tells us a story that Eddie was chasing after Alec for money to give to other people. That's a proper defense, because if Alec owed money to the wrong people, do I believe it's probable? Nah. In my opinion, Eddie was scamming Alec. But that doesn't mean you can't bring it up as a defense, as a third-party culprit defense. Let's continue. The messages revealed a steady stream of communication in the days surrounding the June 7 murders, 2021 murders. According to Hapoutlian, the content and timing of these messages could have changed their calculus for the defense, especially as it related to whether to call Smith as a witness or lean harder into a third-party guilt strategy. And here is some information about Smith, self-described drug runner, longtime associate of Alex Murdaugh, central figure, bizarre roadside shooting on September 4th, 2021, that prosecutors later claimed was a bot-assisted self-ending scheme intending to secure a $10 million life insurance payout for Murdaugh's surviving son, Buster Murdaugh. Long before that, Murdaugh's defense has zeroed in on Smith as a potential alternative suspect in the murders, or at the very least, a witness with important information. In an October 2022 motion, the defense detailed a failed polygraph test, in which he allegedly showed sign of deception when asked whether he shot Maggie or Paul or was present at the crime scene. The defense also raised concerns about Smith's shaky alibi and pointed to his admitted presence on the Moselle property on prior drug runs. Now, folks, if you have been on my channel before, you know my opinions about the polygraph tests. You might as well have a tarot reader in front of you. They really, really do not mean anything. Now, it can be used as a tool to move on in an investigation, but it's not evidence, and it's all about the person handling the polygraph. What questions are asked? How are they asked? In what sequence are they asked? In that case, yeah, it's a tool. Can be a tool in the hands of a proper polygraph examiner. But as evidence, nah. It's just like in, excuse me, everybody who believes in tarot reading, I do not. It's all about the questions. It's all about the questions, and you gather information, and then you say something vague enough to the person in front of you if you're a tarot reader. And all of a sudden, it's, oh, how did they know that? Well, because you probably told them. So that is my general opinion about it. Let's continue. Let's see, where were we? That motion accused prosecutors of failing to turn over key materials, including polygraph data. So this was the the prosecution or the investigators doing the fucking polygraph. Interview notes and DNA comparisons, and asked the court to compel the disclosure of all evidence that could tend to exonerate the defendant or cast doubt on the reliability of a state witness. At the time, prosecutors in the Office of Attorney General Anna Wilson downplayed the significance of the failed polygraph and insisted Murdaugh's attorney already had all the materials they were entitled to. Yeah, and then it turns out they weren't allowed to use this. And as it turns out, the prosecution hid evidence from the defense. Again, folks. If you have a strong case, you don't need to play games. Okay? I say to this day, bringing in all his economic things into that trial, it shouldn't have been there. It should not have been there. If the case of murder is strong, you don't need that shit. You really don't. Let's see here. Let's continue here. This latest revelation surfaces as Alex Murdaugh's legal team pressed forward with the high-stakes appeal, seeking to overturn his conviction. In the December 2024 opening brief before the South Carolina Supreme Court, Murdaugh's attorneys accused former Colleton County Clerk of Court, Becky Hill. Yay, Becky-Boo! You go back, and I believe I have a few videos on that, because Becky Hill is a really, really shady figure with strange connections to politicians, to prosecutors, to investigators. Really, really strange. And she, as you might remember, she wrote a book about the trial. She, with the ghostwriter, in which significant portions of it, she stole from another writer, from a new journalist. So she had to retract the entire book. And as it turns out, well, in my opinion, it was atrocious. Her conduct, as we found out, was absolutely horrendous. Absolutely horrendous. According to the filing, Hill pressured jurors, violated court instructions, and manipulated courtroom proceedings, all in pursuit of personal fame and profit through a book deal. The defense has argued that her misconduct compromised the integrity of the entire trial and violated Murdaugh's Sixth Amendment rights. Then in April of this year, the defense escalated its claim, filing a separate motion accusing the Attorney General of deliberately stalling the appeals process. The motion alleged Wilson's office had, quote-unquote, abandoned all pretense of defending their conviction and was instead, quote-unquote, running out the clock by withholding its appellate brief, which was more than 90 days overdue at the time. Now, with the newly discovered text messages suggesting prosecutors withheld potentially exculpatory evidence tied to a possible alternate suspect, Murdaugh's attorney are signaling that their case for a new trial is only getting stronger and that the fight ahead may unfold more than one front. That's her. When she testified, I streamed that hearing with Becky Hill, and she is such a bad liar. She is such a bad liar. According to a detailed SLED affidavit, Hill allowed third parties unauthorized access to sealed trial exhibits in the final days of deliberations, and later lied about it under oath during a January 2024 Supreme Court hearing. She was also accused of using her office to promote her self-published book, improperly collecting nearly $12,000 in bonuses and federal funds, and interfering in the selection of the jury. Yeah. She had people. She more or less sold tours in the courthouse after hours. It's insanely the amount of misconduct she was into. And here they say, curiously, though, Hill was not charged with jury tampering, raising additional questions regarding the integrity of the SLED investigation into those allegations. Yeah, remember, folks, SLED was central in the Alex Murdaugh trial. And if it turns out that they had information that was never turned over, that if some of their investigations, the results of it were shady at best or tampered with at worst, then it might explain why nobody wants Becky Hill charged with jury tampering. Hill, incidentally, is scheduled to appear in court in Colleton County this Friday, July 18th, 2025. That is 2 days from now, from this recording. And I won't cover it because I am going up north to my godson's wedding. Yeah, I'm so old. My godson is getting married and he already has kids. I mean, seriously, I don't like getting older. First of all, it hurts, and then I'm tired all the time. Yeah, let's move on. The Attorney General's soft delayed response brief in Murdaugh's appeal is now due on August 8th, 2025. So they still haven't filed it. They were 90 days overdue in April. We're now in July, and they still haven't filed it. With the defense expected to file a reply 30 days later. Potentially setting the stage for one of the most consequential appellate rulings in modern South Carolina legal history. If the court determines that Hill's misconduct or the state's alleged suppression of key evidence violated Murdaugh's constitutional right to a fair trial, it could result in the conviction being overturned and a new trial being ordered. That outcome would force prosecutors to relitigate the most high-profile criminal case in South Carolina history, this time under an even more intense national spotlight. I completely agree. I completely agree to this. Now, this trial was huge back in 2023. Enormous. And if it is a retrial, it has the potential of being bigger than the Karen Read retrial. If you're asking my opinion about Murdaugh's guilt or innocence, many things speaks to his guilt. But here's what I usually say. If you have 100 pieces of evidence, 99 of them points to guilt. One says, "No, it's virtually not possible." Those other 99 doesn't matter. And for me, the thing in question is Alex and Maggie's phone. Maggie's phone stopped moving when, according to the data, Alec was at least half a mile away. That is one thing. Second thing is, the prosecution alleged that Alec took Maggie's phone with him to the car, started driving, and tossed out the phone. They had they had identical phones, and their phones recorded different amount of steps, different amounts of distance. That is very strange. So I have questions. Now my standard of beyond reasonable doubt is greater than most others. I admit it. I'm very pro-defense, always have been, always will be. But you have to admit that raises issues. All right, that is what I had for you regarding the Alex Murdaugh case. It seems like, even in South Carolina, prosecutors, investigators, court personnel simply cannot avoid doing shady shit. Okay, have a good one, and I will see you all in the next stream or video. Bye-bye.